Trademarks, copyrights, and patents are all distinguishable things, and even trade secrets are a fourth category of intellectual property protection that are in their own bucket. So if you're asking yourself, why don't I know the difference between a patent, a copyright, and a trademark, don't feel bad. I've worked in a bunch of law firms, and I've had partners tell me that I need to file a patent for somebody's logo. So you're not alone, but patents protect anything that is new, it's useful, it's non-obvious compared to what other people have invented before. Effectively things like machines, or perhaps even software, to the extent it accomplishes some goal that improves science, it advances technology. That's your classic patent type of scenario. There's also a slight modification to that, which is called a design patent. So you might think of the Harley-Davidson motor, the appearance of that particular motor, the V-twin shape. That is actually something that's protected. Even though it's a functional device, it is protected as a design patent, which covers all the ornamental aspects of it. A trademark is a little bit of a cousin to a design patent in some ways, but trademarks, unlike patents, cannot be functional. They cannot have any type of utilitarian nature to them. So with that in mind, anything that is a source identifier could be a trademark. Most often it's a name, sometimes it's a logo, it could be a slogan, but even certain motions, to the extent that one thing moves from one spot to the next spot. If that's something that's distinguishable from its competitors, if that's something that the consumer ultimately knows to be affiliated with that particular company, that could qualify as a trademark. Same is true of color. One could argue the same could be true of smell. So anything that identifies a particular source in connection with products or services, that's a traditional trademark application that you would protect with the United States Trademark Office. Copyrights are a little bit different than those two. Copyrights protect anything that is original and expressive. So your classic copyright scenario would perhaps be a publication, some sort of book or article that was written. Movies are obviously in that category. Music is in that category. So each aspect of copyright is a little bit more tailored to the particular type of industry it protects. One could argue software also could fit into copyright law. If all zeros and ones make up software and you come up with a unique string of zeros and ones, perhaps you could protect it with a copyright. Trade secrets are the last category, and they're really more of an inverse to patents. They really they are protected as a secret if they're used in the course of a business, and they're actually maintained forever as long as you can keep the secret, just like Colonel Sanders chicken, just like Coca-Cola's trade secret recipe. So they didn't disclose those as a patent, even though perhaps some of those things might have been patentable at one point in time, but because they didn't disclose it, they can keep it forever. The inverse is once the cat's out of the bag, you can't put it back in.
Protect your brand with Trademarkia. Register your trademark on trademarkia.com.